when it's red, it's on.
That seems backwards. Oh, thank you. Okay. Are you all, is the city ready?
I'm ready.
Okay. Are we
Are
ready?
you ready?
Yes. Thank you very much. Okay, we'll go ahead and get started. Good afternoon. I'm calling to order the City of Titusville Code Enforcement Special Magistrate hearings for July 8th, 2024 at 2 p.m. My name is Jennifer Nix. These are public hearings for code enforcement violations. These hearings are quasi-judicial, and I'm the special magistrate appointed to hear these cases. Formal rules of evidence do not apply, but fundamental due process shall be observed. Everyone who has a case today will have an opportunity to present testimony. You may present evidence and or witnesses to testify on your behalf. There's no public comment portion of these proceedings. You must be a respondent or be called as a witness in order to speak on a specific case. Everything today is being recorded and all testimony will be under oath. When you are sworn in, please provide your current mailing address so any orders get to the correct address. The city will present its case first and information will be displayed on the screen. Documents may be provided by the city as evidence. The city's PowerPoint presentation will be entered into evidence unless objections are made. After the evidence, I will make a ruling. The ruling will be reduced to writing and mailed to you. If we could swear in the witnesses at this time. If you think that if you're a person that'll be speaking on a case today, please stand to be sworn in. I don't know if they are or not. Thank you. Do you hereby swear or affirm that the testimony that you'll give this afternoon is the truth, the whole truth, and nothing but the truth? I do. Okay, thank you. Okay. Good afternoon.
Good afternoon, ma'am.
And will we be proceeding with the agenda as provided?
The one that I provided for you, the most updated.
Thank you.
Yes,
Okay.
it should start with case number 24-70.
Okay, that's with 701 South De Leon Avenue, owned
Yes,
by
ma'am.
Suha
It'll be a
Walid.
Massey hearing,
Thank you.
and Officer Franklin's.
Okay, what am I doing wrong? Oh. Okay.
Ask the folks in the back to show your PowerPoint. Two main operations.
Talk to you later, buddy. Here we go. Nope.
Oh, no.
Went back to me. Am I supposed to dance? Me either. Here we go. Good afternoon, ma'am. First off, I'd like to enter into, as evidence, the notice of hearing and the previous order from the June 10th hearing.
Okay, and both of those are accepted. Thank you. Thank you.
Okay, this is case 24-70 for property located at 701 South De Leon Avenue. Respondent is Suha Walid there. It was mailed to address 1404 Providence Road, Lakeland, Florida, 33805. The violation was section 30-305A, the Titusville Code of Ordinances, continuing landscape maintenance required. The notice of hearing was posted at City Hall and on the property where the violation exists on June 24. Certified and first-class letters were mailed on June 24th, 2024 also. Again, case was originally heard on June 10th, 24. The respondents who on the property were present and provided testimony. They were ordered to correct the violation on and before July 5th, 2024. To correct the violations, they were ordered to seed or sod the lot area south of the business structure to establish a ground cover. The area was seeded, but to date, the ground cover is not sufficient, it's not been established. If compliance was not achieved, a fine amount of $100 per day commencing on July 5th, 2024, and continuing daily until the violation is corrected, would be imposed. Administrative costs in the amount of $163.75 were imposed. This is a picture that was taken July the 5th. You can see it's very little cover. Another picture of a different angle. Those pretty much look that way today. They have placed a fence around the area to keep traffic off of it, but there has been no more cover established, no sod laid, anything. So the conclusion is the ground cover required has not been established and the property is not in compliance. One of the property owners did contact me Friday morning and said that they had some sod ordered and that they did not know if it would get here in time to bring it into compliance. I've checked it twice today. As of 1:13 this afternoon, it was still in violation.
When you spoke with the owner, did you say when the sod was supposed to get here? Did they
He
inform
said hopefully it was going to get here this morning, but evidently it did not.
you? Okay. Okay. And let's see. That was July 5th at noon was the time for compliance, and then those photos taken July 5th were after 12
Yes, ma'am.
noon? Okay, thank you. And, okay, I could certainly see that there seemed to be some sprigs of green, but not by any means a sufficient amount of
Yes, ma'am.
coverage.
They had actually seeded that area before or around the time of the first hearing, but it has not. As a matter of fact, a lot of it today did not look good at all. It was very brown, lack of water.
Okay. And I recall testimony about it being seeded before, but,
Yes, ma'am.
okay. Let's see, did you have anything further, Mr. Lewis?
No, ma'am, not from my end. This could be them. Yes, it is.
Okay, all right. We're in the middle of the hearing for 701 South DeLeon Avenue, so if there's a respondent here that would like to testify, we've already had the code enforcement officer testify. I'll swear you in, since we had done that previously. Do you hereby swear or affirm that the testimony that you'll give this afternoon is the whole truth?
Yes, ma'am.
Thank you. And can you please give your name and address for the record?
Fawad Salem, address is 701 South DeLeon.
Okay. And Mr. Salem, we had looked at two pictures from July 5th that the code enforcement officer had shown, and I'm sure we can put on the screen again at some point, but anything that you would like to say in regards to the property at this time?
Actually, we came in here to ask for an extension just by a couple of days. We're about to install in the grass pallets. We already got fixed with, we already did the fencing for behind the property and next to the property. But the only thing that we are still en route is to get is the grass.
Okay, so when you say the fencing's installed, what kind of fencing are you speaking about?
I believe there needed to be a cage around the property, just to block anyone from parking on it. And then we needed to install grass.
Oh, was this just to help with the grass being installed, perhaps?
I don't know. But we went for it either way, just to make it double secure around the whole area. And then also we had to move back. I believe that some of the fencing behind the property was also on the cities that we also changed as well.
Okay. As far as the, so I understand, has the sod that you all ordered been
Yeah.
delivered?
No, not yet.
And when is it supposed to get there?
A couple days. I can probably get you in by 3 or 4 days.
And how long, as far as the extension, you said a few days? What is a few days?
3 or 4 days.
Okay.
Yes, ma'am.
Okay. And can I have the photos put back on the screen for a moment so Mr. Salim can see them as well?
Special Magistrate, I'd like to remind the respondent that the compliance date was Friday, July 5th, and 3 days would put you to today.
That is also true.
Those photos were taken July the 2nd,
Okay,
not 5th.
thank you. Mr. Salim, is that what the property looks like at this time?
No.
Okay.
No, when were these photos taken?
The code enforcement officer testified they were taken July 2nd.
July 2nd? No. I believe I called Mr. Frank July 3rd, if I'm not mistaken, or July 3rd. And I mentioned to him that we were going to have the fencing and everything else done. And he mentioned to me that on Monday there was supposed to be another new photos to be taken just to showcase the property, to tell you that we are in progress of finishing everything.
As far as the
fencing and then the grasses in route.
Okay, so as far as the seedling and the kind of grass sprigs that it looks like there, is that part of it essentially what it looks like right now?
No. The seedling, yes, I'm sorry.
Okay.
But the fencing is all installed.
Okay. Okay, if I could actually ask the city another question or two as far as the testimony in regards to the fencing. I know that for the compliance, my prior order had required for compliance that the property would need to, let's see, you could come into compliance by sodding or seeding the lot to establish ground cover in the subject property's lot area south of the business structure. Was there any requirement about the fencing, or is this just kind of?
No, ma'am, fencing wasn't even any part of the case.
Okay,
It's a great addition, and it will stop everyone from traversing with their vehicles all day long. But it was merely about because of the erosion and everything is entering the street and then into our stormwater systems.
okay.
So with that being said, I was just curious, you said it should be arriving. Do you have a contract where you've ordered the amount of sod required?
I have one. I can probably send over to Mr. Frank by today. It's with my father, but I do have some that have already been bought.
Okay.
I haven't dropped me up an invoice. I can send it right over.
Let me ask, as far as so you have a contract, but you didn't bring a copy of it here. Do you have any
No.
evidence to submit that I can review?
I can give it to you within a couple of minutes.
Do you have it in an email or something like that?
No, ma'am. This is
Okay.
a contract just face to face. Whenever we came up the last time, I believe I called Mr. Frank on July 3rd, and then I just had to put, I had to make the measurements that they needed to get done, and then on Monday they came up and got everything else sorted. So they said, listen, we'll probably have it right within a few days. I said, all right, cool. When it gets here, I'll make sure to pay off everything else.
Who is this contract with?
One of the locals knows him from the tenant that we have on 701 DeLeon. He knows someone around. He said, my brother knows him. So I said, all right, listen, you can get a contact. I can get everything in route.
And while I appreciate your testimony about that, there's nothing for me to actually review to see anything about confirming that. Okay. As far as, okay, did you have anything else to offer specifically at this time?
No, ma'am.
Okay, thank you. As far as the city's position goes, as to the request to extend the compliance date for a few days, what is the city's position on that?
The city does not support that request due to the fact that there should have been progress shown prior to the deadline of July 5th, and the next step again, will need to be maintained in order to survive. And we would not be comfortable extending the case at this time.
Okay, thank you. Okay. Okay, I'll go ahead and give my order now, which will again be reduced to writing and provided by mail to you all, to the respondent. I've accepted and considered documentary evidence, reviewing photographs provided by the city and sworn testimony relating to this matter from both city staff as well as the respondent. I do find that the respondent is the owner of the subject property and that all notices were provided in accordance with state law and the city code. I do find that the property is not in compliance at this time and is not in compliance with the previous order, which required the violation to be corrected by either sodding or seeding the lot to establish ground cover by noon on July 5th, 2024. And so I find that the respondent either failed or refused to correct the violations by the previously ordered compliance date. And therefore, based upon the evidence, testimony, and photographs presented during the hearing today, I find that the city has proven a violation, a continuing violation of section 30-305A, continuing maintenance required for landscaping of the city code, and that a daily fine be imposed in the amount of $100 per day commencing on July 6th and continuing daily until the violations are corrected. And again, that future violations of the same section of the city code shall be classified to be repeat violations. So a certified copy of the order can be recorded in the public records to constitute a lien against a property. So the respondent needs to further ensure that the respondent provides notice to the code enforcement department as soon as the property is brought into compliance, such that code enforcement can come out and confirm that the property is in compliance in the future. So please keep in touch with the city in order to stop the daily fine once the property is brought into compliance. Okay, and that concludes this particular item on the agenda.
Our next case, 24-71, 1710 South Washington Avenue. Again, it's a Massey hearing. Officer Flanagan, and we do have the owner present today.
Okay. All right, thank you.
Okay. I have a affidavit of notice of hearing for today's and your order as well.
Okay, thank you. Okay, both of those as well as the PowerPoint presentation are hereby accepted as
right.
evidence. Thank you.
This is for Titusville Square, 1710 South Washington. Again, this was for the openable windows. everything else was brought into compliance before the hearing from last month. And sorry. Got the wrong case in there for some reason. I apologize. Yeah, the notice and everything, the affidavit, everything was posted for the hearing. I was contacted by the property manager last week about the windows. She advised me due to the fact that some of the windows were older and the latches were unavailable, that they would have to replace the windows. And they said that it would be they wouldn't be able to get it done by today or by Friday the 5th. So there was no reinspection done.
Okay.
From what I understand, it's still in violation. The owner contacted me this morning, said that they removed the tape and other issues from the one window. I explained to her that all the windows needed to be operable, and that's what the re-inspection's for and everything. And I explained to her she needed to get with the property manager to resolve whatever issue they were having between them, since the property manager didn't request a re-inspection and told me that they wouldn't be done as of Friday, and they are not done as of today. Nobody's called me to do a re-inspection. And the owner's here today, so
Okay,
that's about, this is the one window that had the issue.
right.
That was visible, and there was other windows on the property that still needed to be corrected per the property manager.
Okay. And per the prior order, the cited violation could be corrected by repairing or replacing the affected windows, and none of
Right.
that,
Correct,
to the city's knowledge.
correct.
Has
To
been
my
done.
knowledge, it hasn't been done, and per the Arita, the property manager, she even stated it hadn't been done, and it's not gonna be done for several weeks until they can get the permits and get the windows ordered and everything.
Okay. Okay, and is there a respondent here that wants to speak as to this matter?
Hi.
Hi, good afternoon. If you could please say your name and address for the record,
Yes.
anyone that's speaking.
Yes, my name Mindy Farm, and this is my daughter Christina Farm.
Okay,
And the address is 1710 Washington Avenue.
okay. And could you spell your first name just so I have it correct?
Mindy, Mindy.
Perfect. Okay,
Farm.
thank you. Thank you. Okay, and anything that you would like to state, now is your opportunity.
Yeah, so my daughter, she can speak.
Okay,
Thank you.
thank you.
So we went by this tenant and we talked to him to make sure that the windows were operable and that we double checked. So we took out the sticks and the tape. He told us that it was just for security purposes to make sure nobody can get in. But then he does just prefer to have the stick there. We told him to take off the tape because it just looks like it is broken. So he has taken off the tape and then takes out the sticks. So we have photos of the windows without that tape and sticks, and it works fine. Do I show you the photo?
I don't think that I can look at the photos on your phone because that's something that needs to be entered into the record.
Okay.
So we need to have evidence that the city can hang on to for the record, which is a public record. Is there, you can tell me about the windows, but unless there's a way that the city is okay with accepting this evidence and getting that to the city now, I don't know that I can.
In the photos, you can see that it looks like a normal window without the sticks, without the tape. The screens and everything look okay with that window. Both the windows, actually. Yeah, so just saying that he just wanted to leave it there for security purposes. If
from my recollection, as well as the order, just to mention, I know that the windows, as previously shown by the city, and which could probably be shown again as far as the prior photos go, that the windows were depicted as being shut and taped off, but also that they had broken latches. And I remember there being more than one window to my recollection. So I don't see that just pulling the tape off the windows would fix the problem. I'm sure the city can speak to that further.
Again, like I said, I have to go by what the property manager told me, and she's saying that they weren't ready and windows had to be replaced, and because they couldn't find latches to fix the windows, so there was no re-inspection done for me to do this until I got a phone call this morning, her telling me that. I haven't been out there though. And this was like an hour ago.
Okay, let me understand everybody's role here to be clear. As far as Ms. Fong, are you all the owner of the property?
Yes, ma'am.
Okay, and who is the property manager that the city spoke with?
Rita, her the property manager for that building.
Yes, the reason I asked her to order the window company to come over to check all the windows, because that time when I received the letter from Code Gym Enforcement, and he said about the window. So when I met him one time at the property, and he showed me the tape around, and the pole was like stick inside the window. So I come to the tenant and ask him why this one is broken, or why he put the pole and the tape around. He say he just want to protect the people not to get into the room, into his property, into the apartment. So that's why he put it in there. So I tell him, please, if it's not broken window or something, could you please take it off? So he did take it off. And I took the picture and I sent for Mr. Jim on June 10, but I probably sent for you not in your one of the number that you gave me. So I think I sent you the wrong one to make sure that I already correct it with picture, and I send you a note. But right now, I think this morning I tried to find out the number. Probably I send you with the different number. So that's why you must be not received. This is the number.
I didn't say I didn't get I will say I got the pictures and the tape is removed off
Right
the
here.
window. But I'm going by what Rita told me last week, that they would not be corrected as of Friday, the 5th, and they would be several weeks before they got the parts to get the rest of the windows fixed, not just that window.
You see,
There's
this
other
is the
windows
one
on
that I send you on the
I'm
training.
not arguing that, and I just stated I got those pictures.
Yes.
I'm
okay.
saying all the other windows on the property that Rita told me still needed to be fixed, and it was not gonna be fixed because they have to order windows and permits to get it done correctly, is what Rita told me.
Yes, I
And I
think,
told her this morning, get with Rita and get this resolved. I can't get in the middle of that. But there was, like I said, there was no re-inspection because there's other windows on the property that haven't been corrected yet, according to Rita.
Yeah, I recall there being multiple windows, not just one window at issue. Mr.
That's
Johnson?
correct, and I think it would have been more beneficial had they brought their property manager here to testify whether they are or they aren't. Because we would have to enter each apartment to see that they are indeed operable by locking mechanisms, which they said there aren't there.
I do wish that there was more evidence for me to actually review in order to evaluate that, as you're stating, the windows to be in compliance, because I don't have something before me that is showing the windows to be in compliance, and I am hearing testimony that tape has been removed and that maybe a stick was taken out of the window, which it sounds like somebody used to so the window can't be opened, but just taking a stick out of the window doesn't fix a broken latch, which was also part of the problem, as shown in the prior hearing. So,
Are we able to get some sort of extension so that we can talk to Rita about this and get it figured out and sorted out? Maybe like 30 days.
I mean, the issue was there was already, the hearing about this and the compliance date was already given as July 5th. I mean, as far as an extension goes, I mean, the order provided for a compliance date and that it's respondent's responsibility to contact code enforcement to request an inspection to verify compliance. So I'm not particularly inclined, I don't find it very compelling for me to give an extension when it was pretty clear what needed to be done by the compliance date that was previously ordered. I'll ask the city what their position is on that, but I don't know that they were going to agree to an extension of any sort.
No, ma'am.
I didn't think so. I'm going to deny the request for the extension of time. And I would suggest that you all immediately do whatever needs to be done or speak with the property manager as to when when the windows can be ordered. I mean, I'm not even sure if they've been ordered yet, and I don't have any evidence about that. So is there any additional information that you can give me, evidence that I can actually review, or not so much?
Yes, because I know I go all over the unit, so I asked if any issue, and so far I don't have the issue. But like I asked Rita to order the company, the window company, to come to check all the window to see anything that need to be fixed or anything need to be replaced. But she did order a few weeks ago, but she told me, I just want to make sure it's, done right. So she told me that it takes, the company she called, it takes some, a certain time to have the schedule. So, yes, so that,
I do wish that your property manager was here to testify as to this today.
I try very, because her responsibility, and she not here, so it's a problem that I try to do all my best to ask her to do the correct thing, but she say I did call a couple company to come to check all around if anything we need to be done, and it just take time to get the schedule for them to come. So I just wish if Rita here, so it will be
No, that would be best, and respectfully, that is your responsibility as the property owner and respondent to bring her or have her come to this to testify. Because from what I'm hearing, she's called around a little bit, but it doesn't sound like she's got you guys on the schedule or actually ordered necessarily any windows, correct?
Yes, ma'am.
Okay. Okay, was there anything else that you haven't stated already that you would like to say, or any additional evidence to offer? Okay. Was that a no? Okay. Okay, then I'm going to go ahead and enter my order, which I'll do verbally here, and then it will be written and provided to you by mail. Let's see. I've accepted and considered evidence, documentary evidence as far as the notices and sworn testimony in regards to this matter. I do find that the respondent is the owner of the subject properties addressed by these proceedings. I do find that the notices were provided in accordance with the city code and state law for this matter, and that notice requirements were met for these proceedings. I find that a violation of section 6-109 of the city code, as well as which incorporates the 2018 IPMC code. So it's specifically section 304.13.2 of property maintenance code, which is openable windows. That a violation of that section continues to exist, and that the respondent was provided a date for compliance of July 5th by noon. And I find that the respondent either failed or refused to correct the violation prior to the previously ordered compliance date. And that's based upon the evidence and testimony presented today. Therefore, as was previously determined, I will order that a daily fine be entered in the amount of $100 per day, commencing, starting on July 6th, 2024, and continuing daily until the violations are corrected. And additionally, that the respondent, if any permits are necessary, you need to make sure that permits are obtained to put in the windows if there are any replacement windows in order to come into compliance. Also, the future violations of the same section of the city code will be classified to be repeat violations, and a certified copy of the order can be recorded in the public records, and then that is a lien against the property. It's very important that as soon as you get the property into compliance, that you contact the code inspectors at the code enforcement department to let them know, because they're not going to just consistently come by to check and see whether or not it's in compliance. That's the respondent, the property owner's responsibility to let them know so they can come do the inspection. So I wish you well with getting that done, and please let them know once you've come into compliance, and you'll get your order in the mail. So that's the end of this proceeding today. Thank you. Okay. Thank you.
Yes, ma'am. Case number is 24-72, 195 Roosevelt. There is no respondent here today, and Jim Flanagan is the officer in this matter.
I do again have the affidavit of notice of hearing and the magistrate order from last month.
Thank you. And those are accepted as evidence. Thank you.
Okay. Again, this would be 195 Roosevelt Street. The violation original charges were for the dead trees on the property along with overgrowth and weeds. Per the city code, we abated that problem and cut the grass and leaned the property on that one. This case was originally heard on June 10th. The owner was given till July 5th to resolve the violation. The overgrowth again was abated. The trees remain on the property, and as of an hour ago, they're still there. There's been no contact with the owner or any indications that anything's going to be done to get it cleaned up. These are, I believe, the original pictures, and these are the same pictures as of today. They're in the same condition. They're still there. They haven't moved, other than the grass has been cut and taken care of by us. The trees, dead trees, are still remaining on the property.
Okay, so as far as a violation, it is just the dead tree violation that exists.
Correct.
There's, all right. Okay, and just for purposes of the record, is there any respondent here today in the audience? And there is not. And did you say that you had communicated with them at all, that they
We've-
communicated with you all?
No, in the past, this property's had several violations. There previously was a house on the property that was removed. I don't know, it was before me, so I don't know if there was a fire or what happened to it.
Okay,
But there has been no communication with the owner on any of the violations, which previously have had other overgrowth issues as well.
okay. Do we know how many dead trees are on the property? I believe before, I don't know if we had a number, and it seemed to be all dead and fallen trees
No.
needed to be removed, but I didn't know if there was a specific number of them.
I think there's one
Just
that's
curious.
actually still standing that's dead. The rest of them have fallen and they're laying on the property, yeah.
Okay,
I think maybe 2 or 3 that have fallen.
okay,
I don't have the exact number, sorry.
all right. Doesn't sound very safe.
No.
Okay. All right, as there's no respondent present today for the hearing, unless the city has anything further, I'll go ahead with my order. Okay. Okay, having accepted and considered documentary evidence and sworn testimony relating to this matter, I do find that the respondent is the owner of the subject property and that all notices were provided in accordance with state law and the city code, and that notice was met for these proceedings today. I do find that a violation of section 13-28 public nuisance violations for the dead tree of the city code continues to exist, and that compliance was not obtained by the respondent. They either failed or refused to correct the violation by the previously ordered compliance date, and therefore I find that the city has proven the violation continues to exist. A fine of $100 per day is hereby imposed commencing on July 6th, 2024, and continuing daily until the property is brought into compliance. And further, respondent is of course responsible for obtaining any required permits and immediately contacting the city's code enforcement department to request an inspection to verify compliance once the respondent states that same has been obtained. Okay, and I will get that order written and we will get that to the respondent. And that's the end of that hearing.
Okay, this one will be case number 24-74, 3945 Ridgewood Drive, and it'll be our last Massey hearing today. And Officer Flanagan.
Okay. I said 3945 Ridgewood Drive was for accessory structure for the fence, the swimming pool, and the pool enclosure. I'm happy to report it. This is in compliance, and it was done before the date of the hearing.
Great.
Or I'm sorry, the compliance date of July 5th. What was it? June 27th, actually, when I went out there. This is a better picture of the pool, which is no longer there. He got the proper permits. The pool was removed, which means he does not need the fence or the pool enclosure anymore. So it's all in compliance. And he is aware of the costs that were imposed. So.
Okay.
Yeah. Do you need, I'm sorry, my apology. Do you still need your order from last month?
Let's see. I mean, as far as the order that the city is requesting, then are you just looking for an order finding the property in compliance and no fine to be imposed, and the costs were already previously imposed, so we're not
Yes, ma'am.
looking for them to be imposed now?
Yes, ma'am.
Like additional? Okay, great. All right, so ordered. Thank you. That was a
Thank you.
great update. Okay, we're on to the initial violation hearings.
Yes, ma'am.
Okay,
24-83, 874 Dow Lane, and Officer May Wright will be the officer for this case.
good afternoon.
All right, I have 4 items to submit. The first is the affidavit and notice of violation. The second is the affidavit for the notice of hearing. The cost recovery statement in the amount of $234.19, and then a copy of the violation section for you.
Okay. Okay, thank you. Okay, thank you. All of these are accepted into evidence.
So once again, this is the initial hearing for case number 24-83. Our respondent is Jeanette McQuiston. Our violation address and mailing address are the same, 874 Dow Lane, Titusville, Florida, 32780. And we just have one violation at this time. It's going to be section 6-109, the 2018 Property Maintenance Code, subsection 102.2, maintenance. So the initial inspection was completed in December 20th of 2023. Upon my return on the 4th of January, the notice of violation was issued, and they were given until January 18th, 2024 to come into compliance. On the January 4th, violation notices were mailed certified and first class, and the certified mail was returned unclaimed, unable to forward as of February 1st of 2024. The notice of hearing was mailed on May 30th, 2024. The certified mail to the listed owner has not been signed for, nor was returned. The notice of hearing was posted at City Hall and on the property June 26, 2024. So We received the complaint from the Titusville Water Department in reference to an outstanding bill and the disconnection of service at this townhome. Inspection of the property found that the unit was occupied, and the townhome lacked the proper premise identification, and an unlicensed motorcycle was parked in the assigned parking. So as of January 4th, they notice if, in December, I posted an orange card asking them to call and make contact with me. So the owner did call me on or around the end of December. I don't have that exact date with me. And she was going to work on making a payment arrangement with the water department, and she was working on correcting the rest of the violations. So I did confirm with water department staff that in January the owner called them to discuss what she needed to do to get water reestablished. As of the reinspection Friday, the unit remains occupied. There's been no payments made, and the water has not been reestablished. So in section 102.2 for maintenance, it just states that the property owner is required to maintain services to the unit. This includes power and water.
Right, so long as it's occupied. I was curious to hear if it was still occupied, and you testified as to that. So it's owner occupied?
Yes.
Right, okay.
So this is a picture of the notice of hearing being posted on June 26th, 2024. Again, the owner's vehicles have been there. They've been moved around the property. There's dogs barking inside. I've seen the trash can move around, personal items, so I can confirm that it's been occupied this entire time. So for the conclusion of fact in this case, the townhome is occupied and there is no water service at this time. So we are, I guess there's no compliance date. We are ordering, we are requesting that the water service be reestablished, and administrative costs being assessed in the amount of $234.19.
Okay, but the city's not asking for the imposition of a daily fine, just that the water connection be reestablished, so they actually have running water as the code requires?
Yes, ma'am.
Okay, or be vacated, right. Thank you. Okay, and just to look at the cost recovery affidavit, then that was $234.19 for the cost recovery that you're looking for, requesting. Okay, and is there, for purposes of the record, is there anyone present here on behalf of respondent who would wish to testify in this matter? Hearing none. Okay, then I'll go ahead and enter my order, which will be reduced to writing. I've accepted and considered documentary evidence, photographs, and sworn testimony relating to this matter. I find that the respondent, Jeanette Cheryl McQuisition, is the owner of the subject property, which is about which we're here for in these proceedings today. I do find that the notices were provided in accordance with the city code as well as the state law pertaining to notices, and that notice was met for these proceedings. And upon reviewing the testimony and evidence, I do find that a violation of 102.2 maintenance of the 2018 International Property Maintenance Code, which is incorporated by Section 6-109 of the City Code, that a violation of that does exist, and that the respondent was provided a reasonable amount of time prior to the hearing to correct the violations. And I'll also specifically find that, this having gone on from December or January through now we're in July, that clearly that is not a temporary interruption in services in regards to the water services at the property. Okay, and respondent either failed or refused to correct the violations within the time period provided prior to the hearing by the city's code enforcement department. And I will grant the city's request in ordering that the respondent either reestablish water to the occupied premises or vacate the premises such that it is not occupied any longer. And I will also grant the city's request for costs to be imposed in the amount of $234.19.
Thank you.
Okay, thank you. And sorry, as to the date that the city had requested, was that August 8th?
August 9th is the Friday before the August hearing.
Okay. Okay, then
I had, after review by the city attorney's office, we had taken off the request for daily fines. But
Oh, right.
That was left in the order, so.
No, I just needed to, and I understand that no fine would be imposed, but I do want to give them a date to do it by, so the order will include that that's to be done on or before August 9th,
Yep,
2024.
that is the Friday before.
Thank you.
Yes, ma'am.
Okay. Okay. All right, and it looks like 24-84 is
Yes,
the
ma'am.
last
And
case?
Officer Wright will
Okay.
also be on this case.
Okay, thank you, Officer Wright. Please go ahead.
So I've got 4 items to submit. The first one is the affidavit and the notice of violation. The second is the affidavit for the notice of today's hearing. The third is going to be the cost recovery statement in the amount of $198.97. And then the fourth will be a copy of the codes being referenced in today's hearing.
Okay. Thank you. Okay, and all of these are accepted into evidence. Thank you.
Thank you. So once again, this is the initial hearing for case number 24-84. So the respondents, Philip M. Kirkland is the listed property owner. Christopher Kirkland is the next of kin for Philip and is also the listed vehicle owners. Our violation address is 4760 Winchester Drive, Titusville, Florida, 32780. The official mailing address is 223 Lady Astor Place, and that's Danville, Virginia, 24541. Also, copies of all the notices were sent to the violation address of 4760 Winchester Drive, Titusville, Florida. So there's 2 code sections in violation for this hearing. It is section 13-73 for inoperable and unlicensed vehicles. And then section 6-109, 2018 property maintenance code, section 302.4 for the overgrowth.
Okay, and just to verify, there is no asserted violation of 20-58E.
That from the hearing notice?
Yes.
That was actually a part of a separate case by a
Okay.
different code officer.
Okay,
And when I sent out the notice of violation, I was just addressing these two sections. So
okay,
these are the only two that we're bringing for violation at this time.
okay, thank you. I wanted to check because I didn't see them on the notice of violation, and I just wanted to confirm that that's what was
Yes,
happening
ma'am.
going forward. Thank you.
So my initial inspection took place April 5th of 2024. The owner was given until April 25th, 2024 to come into compliance, certified, and first-class mail was sent to the Virginia address on April 8th, 2024. The certified mail was returned, forwarding expired on April 24th of 2024. The notice of hearing was mailed first class and certified on May 31st, 2024. The certified mail sent to the listed owner in Virginia was returned unclaimed, unable to forward on June 4th, 2004. The notice of hearing was posted at City Hall and on the property where the violation existed on June 26, 2024. So the initial inspection was completed after I had received a complaint via the phone concerning a cargo trailer blocking the sidewalk in front of this residence. So I did find a trailer blocking the sidewalk, as well as an RV, a red Corvette that appeared to be inoperable. We also had overgrowth all over the property, and then a trailer containing 2 personal watercrafts, jet skis, were also on the property that appeared to be in a inoperable condition. Photos were taken of the violation while on site. A tenant exited the house. I spoke with Clayton Corrento concerning the violations, what he needed to do to correct each of those issues. I have met with not only Clayton Corrento, who lives at the property, but on May 13th, 2024, during one of my re-inspections, Christopher Kirkland was at the property. He had mentioned he had just arrived from Virginia a couple days prior. We discussed all the violations, what he needed to do to correct those. As of the re-inspection, I did one Friday, I also did one this morning. The vehicles all remain on the property in the same conditions as originally viewed. And the overgrowth, weeds and grass over 12 inches do remain on the property. These are the code sections you have in front of you. This is section 13-73 concerning inoperable vehicles prohibited. And then this is section 302.4 for weeds and grass. All of my photos in today's exhibit were taken on June 26th of 2024, and they do reflect what I saw today. So these are, we have the RV starting on the left-hand side, which is inoperable. You cannot see the Corvette behind the minivan. This is the RV, and we've got high weeds and grass in the side yard and in the rear yard. This is on the right-hand side of the house. There are weeds and grass, and in back is our 2 personal motorcrafts, our watercrafts. They've been moved back, and the weeds and grass are growing up and around the boat in the side yard. So for the conclusions of fact, section 13-73 for inoperable unlicensed vehicles, the RV, the car, and the personal watercrafts all fall under the definition of a vehicle, and they do remain inoperable at this time. And then in section 302.4, there are grass and weeds over 12 inches in height on the property. So we are asking the respondent be ordered to correct the violations on or before August 9th of 2024. To correct the violations, we are asking that proof of current registration and valid plates for each of the vehicles, the RV, the car, the watercrafts be provided, and that the owner demonstrates that each of the vehicles are operational. And then for overgrowth, we are asking that the yard be mowed and trimmed. We also are asking that the administrative costs in the amount of $198.97 be assessed. And if the respondent does not comply by Friday, August 9th, 2024, that a fine of $50 per day per violation be imposed until the violations are corrected. And to call the code officer when the violations have been corrected.
Thank you. I have some questions as to just how how each of the RV, the car, and then the watercrafts, the 2 jet skis, how are they considered to be inoperable?
So both Clayton, who is the tenant, and Christopher, who is the vehicle owners, both stated in conversations with me that they do not work. As far as the RV and the car, I was told it was battery issues, but they weren't able to start them. They weren't specific as to what the issues were with the personal watercrafts. And the vehicles have remained, the RV, at least the RV and the Corvette have remained in the exact same spot since the first time I was there till this morning when I went.
Just as to the definition for an operative vehicle that's provided in the notice of violation, I understand, of course, that the RV and the car, if they've never moved in their vehicles designed for highway travel that don't currently have a current tag or registration, that they would be considered to fall into that definition.
So the jet skis are also titled and registered.
Thank you, that's what I was gonna ask.
Yeah, they each have their own registration. The trailer has its own tag and title.
That's what I thought about that it would need to have the
Yes.
trailer tag and title, because it's not as though the
Well, each
jet
of the
ski is a
watercrafts-
highway.
Right, but a vehicle is
Vehicle, you know.
defined to be self-propelled under, if I can, in the notice of violation, I did pull in the portion of the definitions
Yes.
from chapter, and it does kind of define what a vehicle is.
Thank you.
And that's why I felt the watercraft fell under that as well.
Okay, thank you. I hadn't, the way that my page was folded, I didn't see the vehicle definition. I was only looking at the inoperative vehicle, so
It's
thank
okay.
you. Okay, great. Okay, and then, sorry, just to revisit, as to your conversations with Clayton Carento and Christopher
Kirkland.
Kirkland, thank you.
And
Had they stated that that they're trying to fix these things or get a new
they,
battery? I'm just curious as to what their intent is, since I don't.
they did, and I didn't put a picture of the close-up. So on the Corvette this morning, the hood was up. There was a battery charger attached to it. They did not answer the door. I did speak to Clayton by phone, reminding him of the hearing today. He said he would talk to Christopher and have him remind him of today's hearing, but they had not gotten any of the vehicles running, and he wasn't sure what Christopher's decision as to what they were going to do.
Is the Christopher Kirkland person also an occupant of the
Yes.
premises?
From May 13th forward, he's been on site. His listed address in Virginia is the same as Philip Kirkland's, the 224 Lady Astor.
Do they have a garage there that they could store those in?
They do have a garage.
I mean, not that the RV would probably fit in there, but.
I will be honest, the door was open this morning. There isn't a whole lot of room in there.
It's one of their options anyways.
Yes, that is an option for storage of the vehicles.
Okay. Okay, and then just to mention specifically, as I know I haven't mentioned much as to the yard, I can see clearly that the weeds are very high and grown up around the jet skis, which are elevated on a trailer, no less. So I think it's pretty clear from the photo evidence that those weeds are 12 inches.
Yes, and again,
and-
you can't see it here, but the front bumper of the RV, you can't see. The weeds were up that high. They did mow this little side yard that they got to, but the backyard remains as high as the side yard where the jet skis are.
Right. And I'm, with my own eyes, it's hard for me to tell how tall that the bumper of the RV is, as opposed to the jet ski, which I think is even more obvious as to
Yeah.
the height.
Yeah, the
being
jet
over the
skis
12
do sit
inches.
higher than the bumper of the RV.
Okay. Okay. All right, so, for the record, it does not appear that any respondent is present or a witness on their behalf. So, that said, I will go ahead with my order. Thank you, Officer Ray. Okay, I've accepted and considered documentary evidence, including photographs and sworn testimony relating to this matter from city staff. The respondent is not present at this hearing. I do find that the respondent is the owner of the property, which is the subject of these proceedings. I further find that all required notices were provided in accordance with the city code and state law. Bless you. I find that violations of sections it's section 6-109, which incorporates the 2018 IPMC into the city code. I find that there is a section of a violation of section 302.4 of the IPMC, which is weeds, which is shown by the photographs provided by staff and confirmed by the related testimony. I also find that there's a violation of section 13-73, inoperative vehicles prohibited, time limit for disposition exception. I find that there is a violation of the city code, of that city code section, as evidenced by the photographs and testimony in relation to the RV and the red Corvette car and the jet skis, which are shown in the photos to not have moved, and as testified by city staff, they are not working per the property owners. Okay. To correct the violations, the respondent must provide proof of current registrations or valid plates for the inoperable vehicles, which includes, again, the RV, the car, and the 2 jet skis. Further, in order to correct the weeds violation, the yard must be mowed and trimmed. And I will impose a, I will provide for a compliance date of August 9th, 2024. That is
Ma'am?
the date by which the respondents need to correct the violations. Did you have something to mention before I?
For section 13-73, can you include in the order that they need to demonstrate each of those vehicles are operational by contacting me?
Yes.
Thank you.
You're welcome. Okay, yes. So included in the order will be that in order to correct the violation, the respondent must contact the code enforcement department specifically to demonstrate that the inoperable vehicles are actually operational. The respondent will have until August 9th to correct the violations upon the property. And if that is not done, then on August 10th, August 9th at noon to be specific, if the violations are not corrected by that time, then on August 10th, a $50 per day per violation may be imposed. And per violation meaning one violation being the weeds violation and the other violation being the inoperable vehicles, just collectively. Okay. Also to note, future violations of the same sections of the city code shall be classified to be repeat violations. And that concludes this hearing. So ordered. And that concludes all of the actual hearings for today, correct?
Yes, ma'am.
Okay, thank you. And then is there a code enforcement manager's report?
Have no report this month, ma'am.
Okay, thank you. All right, then we will stand adjourned at 3:25 p.m. Thank you.